You're listening to Rights and Reality, the show that breaks down the laws that shape our everyday life without boring legalese. I'm your host, Miss Roxy, and today I'm joined by our guest, Firefly. And today we'll be talking about what happens if an officer searches your home or your car and they don't have the right to. That's the world of illegal search and seizure. We'll unpack what it means, why it matters, and what you should do if it happens to you.
Imagine this. It's late. You're at home watching a movie. A loud knock, and then boots at your door. Officers push in, guns drawn, and start rifling through drawers. Chaos. You're terrified. Later, you learn they didn't have a warrant. Did they break the law? Should the evidence they found be used against you? Well, this isn't just drama for TV. This actually happens, and the consequences are huge. Today, we'll walk through the rules that police must follow, the common ways searches are ruled illegal, and what remedies exist when your rights are violated. At the most basic level, search means police looking through your person, home, or belongings. The word seizure means taking something or taking away your freedom, for example, an arrest. The Fourth Amendment to the United States Constitution protects people from unreasonable searches and seizures. That's the core belief. In order to search your home, police normally need a warrant. A warrant is a court order signed by a judge, which is supported by the idea of probable cause. In order for probable cause to be found, there must be clear evidence of a crime. Warrants must describe the place to be searched and the items to be seized. This is to keep from vague fishing expeditions leading to a false arrest of the suspect.
So, no warrant, no search. But of course, there are important exceptions. Let's walk through the major ones. Number 1. Consent. If you voluntarily agree to a search, no warrant is needed, but consent must be voluntary, not forced. You can always refuse saying, I don't consent to a search is legally meaningful. Number 2. Search incident to arrest. If you're lawfully arrested, officers may search you and the immediate area for weapons or evidence that could be destroyed. Number 3. Plain view. If an officer is lawfully present and sees incriminating evidence in plain sight, they can seize it. Number 4. Exigent circumstances. If waiting for a warrant would create danger, someone's life is at risk, evidence is about to be destroyed, or a suspect is escaping, officers can act immediately. Number 5. Vehicle searches. Because cars are mobile and have a lower expectation of privacy, courts allow more traffic related searches in some scenarios. Still, probable cause or another exception is usually required. Number 6. Stop and frisk. Police can briefly stop a person based on reasonable suspicion, a lower standard than probable cause. If they reasonably fear for safety, they can do a limited frisk for weapons. Number 7. Administrative and regulatory searches. Some searches, for example, inspections of businesses in certain industries, have special rules.
That's a lot of exceptions. The takeaway: there are ways police can search without a warrant, but each exception has legal limits. If officers step outside those limits, the search can be illegal. A few key Supreme Court cases shape this area. For example, first, Katz versus the United States in 1967. This case established that the Fourth Amendment protects people, not places. It introduced the idea of reasonable expectation of privacy. Think, is it private to leave a diary in your locked drawer? Likely so. Is it private to shout something in a crowded street? Absolutely not. Next is Terry v. Ohio in 1968. This allowed stop and frisk when officers have reasonable suspicion that someone is involved in a criminal activity and may be harmed. A few years before this is Mapp v. Ohio in 1961. This case made the exclusionary rule apply to states. The exclusionary rule is that evidence obtained in violation of the Fourth Amendment generally cannot be used in trial. The final case, United States versus Leon in 1984. This case introduced the good faith exception. The good faith exception is if officers reasonably rely on a defective warrant, evidence might still be allowed. These cases show the balance courts try to strike between privacy and law enforcement. But when is a search actually illegal?
A search is illegal when it lacks the required legal justification or when the police exceed the scope of their authority. For example, searching your locked bedroom without a warrant and without an applicable exception. Another example is using consent that was obtained through threats or deception. The third one being conducting a frisk that goes beyond checking for weapons. And finally, searching belongings found during a traffic stop when the officer lacks probable cause or consent. Importantly, the same set of facts can be judged differently in different court context matters. What the officers knew at the time, how the encounter unfolded, and whether the person's rights were clearly asserted is what's important. The main remedy in criminal cases is the exclusionary rule. Evidence obtained through an illegal search may be suppressed. That is excluded at trial. If key evidence is suppressed, prosecutors may have to drop charges.
In contrast, however, the good faith exception can let evidence in if police acted under a reasonable but mistaken belief, like relying on a warrant that turns out to be invalid. Courts also sometimes apply the inevitable discovery doctrine. If the evidence would have been found lawfully anyway, it might still be admitted.
Civil remedies are possible too. People sometimes sue officers for constitutional violations, though immunity rules and procedural hurdles make these suits complex. Let's get practical. If you're stopped or your home is approached, what should you do?
Short, clear steps. Stay calm and be polite. Escalations can make things worse. Know your rights. You have the right to remain silent, you have the right to refuse consent to a search, and you can ask, am I free to leave? If the answer is yes, you can calmly walk away. If they ask to search, say no if you do not consent. Say, I do not consent to a search. You can repeat it and remain silent. Do not physically resist. Even an illegal search can be handled later in court. Resisting can lead to arrest and further charges. If it's safe, record the encounter. Many jurisdictions allow for recording police in public. Know your local laws. Write down details afterwards. Officer names, badge numbers, car numbers, witnesses, license plates, whatever information matters if you later challenge the search. Contact a lawyer. If you believe your rights were violated, search out an attorney immediately.
Two quick caveats. Asserting your rights doesn't mean being rude, and laws about recording police vary by state. When in doubt, record visually from a safe distance or call a lawyer.
Quick myth busts. Myth. If police have a warrant, you must answer all their questions. This is not true. In reality, a warrant lets them search, but you can still remain silent and consult a lawyer. Another myth. Saying, I don't consent guarantees that the search won't happen. This simply is not the fact. Well, in a perfect world, this would be the case. In reality, police might search you anyways. But saying you do not consent helps you build a better legal defense. The final myth, recording police is illegal everywhere. In reality, most states allow recording public police activity. And while a few have restrictions on recording audio, a lot of them do not bar recording video. But by all means, please check your state laws.
Let's boil this down with a short example. An officer pulls someone over for a busted taillight. While talking, the officer asks to search the car. The driver says no. The officer says, I'll search anyways, and starts opening the trunk. If the officer lacks probable cause, no smell of drugs, no visible contraband, nothing indicating a crime, that search is likely illegal. If drugs are found and charges follow, the defense can move to suppress the evidence. Maybe the case gets dismissed. Knowledge of illegal searches and seizures matter because they protect bodily privacy, home sanctity, and our basic freedom from arbitrary state power. If you take one thing away from today, it's that you can politely refuse a search and ask for a lawyer. That simple step preserves legal options later.
If you want to dig deeper, look up your state's laws on recording police. Read short primers from reputable nonprofits such as the ACLU and local civil liberties groups, and consider contacting a criminal defense attorney or legal aid clinic if something happens. This episode isn't legal advice, just a guide.
Thanks to FireFly for joining. If you like this episode, subscribe and leave a review, and let us know what you would like to see next. This has been Rights and Reality. I'm Miss Roxy. Stay curious, stay safe, and know your rights.